So good afternoon and welcome to this session on the guidelines on investigation or on investigating violations of international humanitarian law. I'm Marco Sassoli. I'm director of the Geneva Academy on International Humanitarian Law and Human Rights, and this is a joint center of the University of Geneva and the Graduate Institute of International and Development Studies, and we do training, we do teaching, policy studies, and we are somehow a hub where people meet to bring humanitarian law and human rights forward. And we are particularly proud that we were able, through our Swiss IHL chair of the Academy, Noam Lubel, whom I will present later, to partner with the ICRC, which is represented by Jelena Page, to contribute to these guidelines on investigating violations of international humanitarian law. One of the subjects of this conference is to bring IHL home, and I think this is really bringing IHL home, because obviously 99.98% of investigations, ideally 100% of investigations, should be domestic investigations, and to investigate is essential for different reasons. One is to stop violations, the second to prevent violations, in my view, although third, to show that certain conduct was not a violation because before you can say that, you have to investigate the conduct, and finally to offer the victims of violations redress. And international humanitarian law does not contain anything about when an investigation has to be started and how an investigation, and there are very different kinds of investigation, has to be conducted. And therefore this 6 years process with many people, some of them I see here, but most are in Geneva, but are in the drafting committee, obviously, were involved, and from all around the world, experts and practitioners participated and allowed us to produce these guidelines. I would also like to thank the government of Switzerland, which supported this, and certain parts of it, also the Netherlands and France, and obviously all the people who participated. You see their names at the end of this booklet, and I'm very happy to see that the three main authors are present here. So Professor Noam Lubel, who is a professor at the University of Essex Law School, a former head of the law school, now director of the Armed Conflict and Crisis Hub, but who is an IHL, and I see a lot of faces who are familiar with IHL, are obviously familiar with him, and Jelena Page, who is the senior legal advisor at the legal division of the ICRC, and who has previously been responsible for the reaffirmation and development of IHL project of the ICRC, and even more recently about the project, the intergovernmental process to enhance respect for IHL, and Claire Simons, who had an essential role in bringing this together, is also in the room. So the authors are here, and I can pass the floor to two authors. I think Jelena Page will first speak about the process. Please, Jelena.
Thank you so much. I too would like to say how pleased and honored I am to be here and to be able to provide brief remarks on the guidelines on investigating violations of IHL. The division of labor is such that I will give a bit of background, in particular about the process, about why investigate, about the contents of the document, and then Noam will provide remarks on the challenges, some of the challenges that we had in putting it together. As Professor Sassoli has said, of course, investigations of IHL are critical for ensuring better respect for this body of norms. And let me say, in the context of the international conference at which this event is taking place, that many challenges have been discussed and will still be discussed by the end of tomorrow, but that ensuring better respect for IHL is the single abiding most important challenge to this body of law, and I think all would agree with that. As we all know, there's not a single way to improve respect for IHL. It takes a multitude of measures, that's very clear. But investigating, as has been said, violations and establishing indeed whether they took place and accountability if they did, is one of the most efficient measures to ensure respect for IHL on the ground. Now, in terms of the reasons for investigating, we can talk about legal and non-legal reasons. Very briefly, I would like to remind you that in terms of the law in international armed conflict, the Geneva Conventions and the Protocol 1 provides that states have an obligation to prosecute grave breaches. They indeed have the obligation to bring persons suspected of such breaches before their courts or to extradite them under certain conditions, and they must have effective penal legislation to that effect. There's also a category of crimes, other serious violations of the laws and customs of war that likewise must be prosecuted by states, at least by the territorial and the state of nationality. And their list, I would suggest, is best found in the list of war crimes, other serious violations of the laws and customs of war contained in Article 8 of the ICC statute. Finally, what is very often forgotten is that IHL consists, or rather, IHL may be violated not only in terms of criminal activity, but there are a range of IHL violations that happen of a non-criminal nature when the provisions of the treaties are not implemented. So, for example, just to take a really, really simple example, if, say, there is no marking of the Geneva Conventions in a prisoner of war camp, they haven't been posted in the languages of the prisoners of war, that is not a criminal violation, obviously, but doing that is essential to enabling the actual implementation of the conventions, and, for example, enabling POWs to complain in cases where the conventions are not being implemented. So there's a whole range of norms in IHL that states are likewise obliged under the conventions and AP1 to suppress, not criminally, but to take administrative measures so that they are prevented or do not happen again in the future. Now, despite the fact that IHL implies a duty to investigate, because it does require prosecutions, as I just said, it has no particular provisions on investigations in armed conflict. And at the same time, state practice and state legislation in this area are incredibly varied and disparate. And as has been mentioned, the purpose of this project and of the document that we are presenting today was to determine when should an investigation take place, what types of investigations are available, and then finally, what are the legal principles and safeguards that should accompany such investigations. I would suggest that this document is in that respect a gap filler, because a similar document does not in fact exist at the international level. And the process, when it started in 2014, as was mentioned, started out by an expert meeting convened by the Geneva Academy and Professor Lubel, at which experts gathered around the table had very different views on whether there was a duty to investigate, what did it consist of, etc. I'm not going to go into the process in great detail, except to say that there were 5 expert meetings held until, in fact, the spring of this year. that a range of people were involved: military experts, government experts, academics, and NGOs, who very generously contributed their time to the process, but that in addition we conducted a range of bilateral consultations with experts as well. Claire Simmons, who has been mentioned, the researcher who is a PhD candidate at Essex University, did an enormous amount of research into legislation, into the academic literature, UN and NGO and other documents. And all of these sources are in fact contained in the annex to the document. But at the end of the day, the guidelines, which are of course non-binding in nature, remain the responsibility of the Geneva Academy and the ICRC. So what we arrived at after these years of work on the document is not a text that is a blueprint for investigations as such for every state on the planet. I mean, that is simply not possible. The systems are in existence for the most part, and they're very varied. What we attempted to do is sort of twofold. One is to present legal and practical issues that states dealing with investigations should think about, both before investigations begin in peacetime, when they're putting the system in place, as well as once an investigation indeed needs to take place. So we were very careful, I think. We've succeeded in being sensitive to the national differences in legislation and practice, and that was one of our aims from the beginning. And then the second goal was really to provide a broad framework for investigations and to put forward the legal principles and safeguards that should guide an investigation process. And Noam will say a little bit more about that in just a few minutes. In terms of the audience are primarily state militaries because, as has been mentioned, they are responsible and would have an interest in undertaking investigations. So let me just briefly say that the non-legal reasons for investigations in bullet point form are the fact that investigations may be a source of very important information for governments in terms of why a military operation or operations succeeded or failed. They can be a basis for understanding what lessons should be learned, what good practices may be extracted. Investigations are incredibly important for keeping discipline and good order in the armed forces. They're important for maintaining the credibility of IHL as such, and they're also important in terms of, in some cases, if in military operations states are seen to comply with the law, they can also actually help, to some extent, build trust in the military actions themselves. So in terms of the audience, however, apart from militaries, we're also hoping, obviously, that in particular sophisticated non-state actors, non-state armed groups, may find this document of use, and similarly anyone else, whether practitioner, academic, in any part of government, NGO as well, may be guided and may find the document useful to the extent that they may be engaging either with states or non-state armed groups on the issue of setting up an investigation system in international and non-international armed conflict, obviously. In terms of the content of the guidelines, I was losing all my documents, I would simply say that, sorry about that, that the guidelines start out with the understanding that the principle of an effective investigation is what must be aimed for. Once again, Noam would talk more about what that is. There's a section in the beginning of the document, and I see some of you are leafing through it, on concepts and terminology, which I think the three of us, with no particular humbleness, feel very proud of, because it is actually the product of our thinking and our formulations, because a lot of the terminology that you will find in the document is actually not defined anywhere else. And of course, it is defined for the purpose of this document. We're not claiming that it's universally accepted. But it was quite a challenge and quite a struggle at certain points in time to come up with the terminology that is included. The document, of course, talks in one of the sections, one of the main sections, about the practical steps that states and others need to take in relation to an investigation. So we talk about recording of military operations as a prerequisite to investigations. We talk about action on the scene by commanders, and we talk about reporting. How should the reporting process within a military or state bodies be organized in order to ensure that reports on incidents that may need to be investigated come up the chain? And we also, of course, talk about external allegations and how they should be handled. All of this in the flow chart that is also included in the document should lead to a very important moment, which we called the assessment phase, which means that the information, whether internally gathered or externally reported, must be assessed by an appropriately independent and impartial body to determine whether an investigation should take place, if so, what kind, criminal or administrative, and then whether further facts may be also necessary to be gathered in case they do not exist. And finally, perhaps that the opening of an investigation rather is not necessary. The document deals with criminal investigations as well and talks about the principles of independence and impartiality, thoroughness, promptness, transparency. I would just say in that respect that when reading the document, and of course that was an issue that we had, is that here we're talking about a process that takes place within the military primarily, and that we're not talking about, for example, independence and impartiality of fair trial standards that are expected of courts. We're talking about these standards as applied to the investigative phase, and that is simply something that should be taken into account when looking at the document. And of course, we use the criterion of feasibility very often, because that is indeed, in situations of military operations and armed conflict, a criterion that needs to be taken into account in assessing whether the legal principles have been implemented. I'm almost done. The second type of investigations that we deal with are administrative investigations, non-criminal investigations to suppress violations of international humanitarian law. We talk about two types: administrative investigations into the acts of individuals, and then systemic into such investigations of a systemic nature. And then also we talk about policy-related violations, and most of us are working in the international level, and here we're talking about violations that take place because there's either a deliberate policy by an authority to violate IHL, or there's willful disregard for reports coming up that violations are taking place. And so we suggest what should be done in such cases to ensure indeed that those type of policy violations can be addressed as well. I can't go into all the aspects of the document, except to say, which is dear to my heart, that the last guideline, and there are 16 guidelines in the document with a commentary, is the need to have legal advisors in the armed forces, not only in international armed conflict, which is of course already applicable to international armed conflict under the Geneva Conventions, or rather AP1, but that also having legal advisors to the armed forces in non-international armed conflicts, which are prevalent today, is absolutely critical to ensuring that the law can indeed be implemented as it was meant to be. So thank you very much for your attention. Pass to Noah.
Thank you very much, Jelena. I give immediately to Noam.
Is it working? Okay. So I'm going to get a little bit more into the substance. And so I'm not going to go through the guidelines, but instead, cutting in and out, huh? Okay? So instead, what I want to do is to talk about some of the challenges that we had around particular areas and how we try to resolve them. And so the first and an obvious one dealing with a subject like this is when you look at the source of any so-called duty to investigate, right? And on what law did we actually base this? because a lot of the discussion when you talk about a duty to investigate, often you end up coming to human rights law rather than IHL. So IHL, in terms of explicit treaty law, there's not much. There's the repress and suppress, but that even doesn't necessarily give us, well, it doesn't give us much detail on what that means. We read investigations into that, but beyond that, there's very, very little in IHL. And so we were faced with a big dilemma. Do we start using human rights law in what is essentially, for many purposes, sort of part of the IHL world? And looking at this, we spent quite a bit of time deliberating, and we ended up with, I suppose you could see it as almost trying to sidestep the issue, but I think it actually worked, and it worked quite neatly. We realized that we didn't need to start getting into in-depth discussions over the interplay between human rights and IHL, because at the end of the day, once we had these expert meetings, we're sitting around the table, and it doesn't matter who was there, whether these were the military lawyers, the government lawyers, the NGOs, nobody denied the fact that when there is a concern over a possible violation of IHL, there is a need to investigate. Nobody questioned that. And equally, nobody questioned that when you have an investigation, it needs to be an effective investigation. Meaning you have to do everything within feasible, within your resources, within the context, and with good faith. Right? And again, there was wide agreement around the room, and we just decided to use that wide agreement as our starting point. So rather than to sort of try and ground this in case law of the European Court of Human Rights or whatever, we just simply said, look, everyone can agree violations need to be investigated and investigations need to be effective. And for that purpose, we then also added a definition of what we mean by an effective investigation, which you can find in the document. But again, it goes to context, it goes to resources, it goes to good faith. And we put that in as the sort of the standard that should be aimed for. And in that sense, I think we managed to avoid getting mired in some of the more academic discussions over interplay between frameworks and we had a starting point that nobody has questioned, not at the time and not since this has come out. The terminology section was particularly important, as Jelena mentioned, because what we were trying to do, and again, this was a problem we recognized early on when we would start talking about certain aspects of investigations, you'd suddenly have people around the table from different systems saying, oh, well, that doesn't fit our system. That doesn't fit our system. No, when you use this word, for one country it means one thing, for another country it means something completely different. And so we had to have this very clear terminology section. And the aim here was to try, and you see this also in the flow chart, to try and come up with something that, despite the differences across the various military and legal systems, to come up with something that in effect can be translated to any system. So anyone looking at this, they might realize that we use certain terms and phrases differently to how they use it in their domestic system. What we urge people using this document to do is not to get too hung up on that difference, but just to take a look and see, right, can I map this onto my system? Okay, I know they use that word, but here's how they defined it. That essentially is the same as some other word that we use in our system. And I think we came up with something that can be mapped neatly, at least onto every system that we've looked at, which was a big challenge. I mean, just think about differences between common law and civil law systems, the different military structures, problems that you have in terms of investigations, where some states they'll have a military police that's part of the military. Another one will have a military police that does investigations, but they answer not to the military, but within the Ministry of Defense, another to the Ministry of Justice, and another where the civilian police does investigations. Right? And then within each one, they have different words and different phrases for, with one place, when they talk about disciplinary measures, they mean something administrative and non-criminal. And another state has disciplinary measures, and disciplinary measures are part of their criminal system. Right? So these are just examples of some of the problems we had to deal with. And again, that's why if you're trying to use the guidelines, you have to go through the terminology section first. It's critical because that's the only way that it'll make sense. But once you do, we are fairly confident that it will make sense. Another challenge that we had, and this is reflected in the subtitle, where we called it law, policy, and good practice. So when we started out, we were having these big debates. Do we aim for something that we're going to call the sort of minimum standards and make it just purely hard law and say these are the obligations? Do we go for best practice? And both of those, and anyone here who's been involved in trying to promote and advance the law knows that there are pitfalls with both. Minimum standards, you end up with a race to the bottom. If you just call it best practice, people say, well, it's not law, so we ignore it. And we ended up, again, doing something in the middle, I suppose, by talking about law, policy, and good practice. And that's because we couldn't do just law, because there was very little explicit law on investigations, certainly not in treaty form. And as I said earlier, a lot of it ends up being case law from human rights bodies. And that's not what we wanted to end up doing, trying to argue with people whether the case law from Strasbourg binds the US military. That wasn't what we wanted to end up doing. So we recognize that we need to do a mixture of law, policy, and good practice. And at the same time, being careful throughout the document when we use must, shoulds, and so on, still making certain points that some things are hard law, and other things being, let's just say, strongly recommended. But it also meant that we were able to include issues that you might not have necessarily thought of in the context of investigations. So some of the initial guidelines, for example, right at the start, talk about the recording of military operations. And here we're talking about the need to record all military operations. So we're not talking about violations, right? We're talking about, before there's any concern over violation, the fact that there's an expectation that militaries capture information on everything that they're doing. This is not something that you'll find in any legal source, certainly not in much detail. But how can you have an investigation if you don't have information more generally on the military operations that were occurring? So this is a type of example where we had to take something and look at practice and look at policy and then create a guideline around it. And it was interesting because we, just on recording of operations, we ended up having almost a full day of discussions on this. We thought this would be sort of quick, and in one of the first meetings, it took a long time. But again, we ended up with something that is quite realistic, that the military members of the expert groups, at the end of the day, although they were resistant, I must say, some people to the idea that we're putting it in a guideline because, again, what's the law on this? But at the end of the day, everyone recognized, no, this makes sense. And many militaries, that's what they do anyway. They have methods of capturing the information of their operations, whether it's through debriefing reports, through electronic logs, through just keeping copies of rules of engagement, and all of these things are detailed in there. So in terms of sort of law and policy and practice, quite a few of the guidelines end up collecting information on things that we might not have necessarily thought of legally initially as being part of investigations, but are actually critical. The same with a guideline on what is a commander supposed to do at the scene of an incident. Right, and talking about the need to train commanders for these situations. So there were lots of examples of these types of things, and you can see that throughout the guidelines. We had to tread some very tricky ground when we dealt with issues such as independence and impartiality, as was mentioned, and here a lot of that is due to the fact that there are certain preconceptions and assumptions about independence in this context that tend to come mainly from human rights cases involving trials. And there's actually a lot less around military investigations, so much less that actually Claire, the third co-author, has ended up doing a PhD now on this particular topic of independence in military investigations. And we had to deal with this in the documents and come up with something that we felt was both practical, reasonable, and true to the law. And again, remembering that we had both military and human rights people involved. And so I would urge you to go through the guidelines with regard to that. And you can see that we had to consider differences on, say, independence and impartiality between criminal investigations, administrative investigations, also accept and understand the differences between different systems. And this was one place where we also did have to recognize that some of the practice is an outlier and urge for a change. So had to deal with systemic problems. This was very important. This is one of the things, again, that's not always captured in existing systems, investigations in states, but to talk about the need for the process within a military to be able to capture when something might be a systemic problem. And there are lots of examples. The one we use so often that we got a bit tired with it, but I'll mention it anyway because it's an easy one to understand, is if something goes wrong in a military operation and the soldiers report back that it was a weapons malfunction. Right? The need to not to just say, oh, well, then, mistakes happen, but to actually make sure then that there isn't an inherent problem with that weapon that might repeat itself, even if nothing else has happened anywhere else yet, but to have a system in the military that stays on top of these things to ensure that you don't have repeats and it doesn't become more widespread. Or if the problem wasn't because a soldier deliberately did something wrong, but there was actually something that was not clear in the rules of engagement, to be able to, again, uncover that and make the change at the systemic level. So we gave quite a bit of attention to this as well. We also had to look at what do you do when the problem is actually a problem of policy, where there may be some intention there with regards to violations, and talk about the need for domestic systems to have some kind of oversight body that can deal with this. And the last point I'll make, I know we're short on time, is, and this was also very important for us, to both include a separate guideline and to reference throughout other guidelines the importance of state responsibility. Because in the discussions of the IHL violations and the attention that tends to be given, there's often perhaps an unbalanced attention given to the need for individual criminal accountability when there's a violation, which doesn't help us when we're talking about violations that are not criminal. And I can remind you that some of the most important rules in IHL actually are not rules around precautions and so on, have not been criminalized in that sense. So we can't just be focusing on criminal accountability. And secondly, IHL at the end of the day is a branch of public international law, and there's state responsibility attached. And so one of the things that we stress throughout the guidelines is the need that, in addition to any kind of investigations that look at individual accountability, there has to be recognition of the need to investigate and look for state responsibility. That this might require, for example, a separate unit. And we know, military lawyers investigating on the ground might not be the ones, or military police that talk about state responsibility. In which case, there needs to be some kind of other unit in the domestic system which receives the same information about violations and is in charge of looking at the state responsibility aspects and steps that states might need to take in response. So that was a key point, and that was actually one that it was interesting. A lot of the military people involved in the guidelines actually were very pleased with this, because they felt that sort of within their own systems, often state responsibility is not quite taken account of, and they were actually quite pleased to see this. So those are just some of the substantive issues and challenges and how we address them. You have, of course, a lot more detail in the guidelines themselves. Thank you.
Thank you very much, Noam. Now we have some minutes for some questions. Please. Yes, welcome.
Yes, hello, good afternoon. I'm representing the mission of Egypt, and I also happen to be a student in the Geneva Academy in the Executive Master Program. Thank you very much for this very useful report, and I think it gathers a lot of work and efforts that have been exerted the last period to ensure the investigations and the violations. However, I just wanted to ask you about the violations of non-state actors, so the organized armed groups. And nowadays we have the traditional format of the armed conflict between two states is disappearing, and we're having more non-state armed groups involved in the armed complex, even if it is of international armed conflict nature. And we have in Yemen, we have in many areas around the world. So how far are these guidelines applicable, and given now the dilemma that we all talk about the compliance of non-state actor with international humanitarian law? So how, I understand I read that you have a sentence in this report saying that might be useful for the non-state armed group, but how is this, can be this applicable on them? Is it via the states or even by the hierarchy of the organized armed group and the structure? And thank you once again, this is a very useful report. Thanks again.
Thank you very much for this question. May I start with one remark? The problem is that you imagine how states would have reacted if we had made guidelines for investigations by armed groups. States have a schizophrenic attitude to that because on the one hand, understandably, they want to have the armed groups respecting IHL, but they don't want to have any procedures because this would, states fear, give them legitimacy. So probably we couldn't go further than to say that these, which is based, indeed, we had no representatives of armed groups, but I take it very much up your suggestion for the Geneva Academy to launch a research project on how armed groups can realistically make investigation. Anyone wants to?
There isn't actually that much to add. The problem being, this isn't a particular problem with regard to investigations by armed groups. This is a problem with regard to the obligations of armed groups and what can realistically be expected from armed groups across the spectrum of IHL. And the growing amount of IHL that we've said applies, and what's realistic, what's not. How do they do that? This is part of a bigger question. And my sense is, we couldn't include it. We wouldn't have been able to resolve that question in a project like this. We couldn't include it partially for the reason that Marco mentioned, and in terms of how this would be used with armed groups, I would say in the same way that we use any other IHL instruments right now with armed groups, it's the same problems and the same thing we need to apply. It's not unique to investigations.
Hi, Ilya, former and future ICRC staff. So I have a question about the ministries and the militaries that you mentioned. I've seen in the acknowledgements that you have the Netherlands, the French, Swiss. A question, have you ever discussed or had any feedback from, let's say, non-Western or Northern ministries, authorities, militaries, and what's the take? Thank you.
Yes, thank you very much. As you will have seen from the annex, we really made a conscious effort not only to include Western militaries and ministries in the research, and thus you have a range of states whose representatives, in a purely personal capacity, took part in the project. So it is extremely important that this be a project and a document that is used widely. The document was just issued at sort of the middle of September. It's taken us a while to also, this is the first time we actually have booklet form copies, so this is a first. And both the ICRC and the Geneva Academy, of course, intend to go forward in disseminating the document and engaging with states in discussions on implementation of the guidelines. And I can report from the last several weeks, or since September even, that there has been quite a bit of interest from certain states and even regional organizations in putting together expert meetings and finding other ways of trying to embed the guidelines in domestic or regional law and practice. So that's the future. Thank you.
Just to add, the countries that you read out, that's from the bit of who contributed some financial support. Right, that's all. And so yes, there were those three. But in terms of the people that took part, I mean, this went from Nigeria, Niger, Uganda, Malawi, Saudi Arabia, Colombia. It was Pakistan, Russia. I mean, this was across. This was by no means a Western project in that sense.
Perhaps we have time for one more question. Well, if there is no one, then it is just left to me to thank our two panelists and all of you for your attendance, those who asked questions and those who didn't ask questions, because otherwise we couldn't have respected the timetable. And I recommend you to read, consult, and take into account in your practice these guidelines. Thank you very much.